Thank you very much for the invitation. This is a very important topic for cybersecurity for freaks, and I've done masters in computer security, and I'm always the odd one out that talks about law in an environment of engineers. Anyway, I'm used to that. And when I was asked to come, they asked me to make a list of coincidences between law and computers. As we say, no one is a hacker unless he has a sweatshirt, a sports suit with a hood. So I make a comparison between hackers and lawyers. I also have my hooded sweatshirt. Anyway, what I want to say is that computers as well as lawyers are very similar. Some of us write and examine legal or computer codes, but we are both interested because laws and programs are not very different. On the one hand, we can see there's an intellectual property issue, and that is because computer programs are subject to intellectual and not industrial property. Because IBM put a lot of pressure to put these rights towards a copyright, whereas in the United States they're more heavily biased towards industrial property. And the argument was that it was a language. Computer programs are a language, and it had to be processed as if they were books, literary works. So even though in theory, even the laws, who are basically legal codes, norms, instructions to be followed, and computer programs also have similarities. However, they are developed with different criteria and not always logical in the case of laws. So then I mentioned the smart contracts. So the information we heard about computers. So then when we have independent, automatically driven cars, we won't need a circulation, a traffic code, because we won't be free, not even to infringe the laws. So, because we will go to a system in which the DGT, the Traffic Authority of Spain, will convince us that we have accidents driven by robots or by humans. We'll have a period of coexistence, and in that period it will be demonstrated that more humans cause accidents than machines. So then there will be rebels and inconformists and said, we don't want to stop driving, I don't want to yield driving. So the legislators will come in and say, well, okay, you are free, however, which is what the traffic authority is doing right now. I'm following it closely. They are talking with car manufacturers so that they build in series driver-assisted driving to help us, of course. But this assistant with a geolocation will be able to know every second if we are going beyond the speed limit in that specific road, or if we keep the safety distance from the next car, or if the safety belts are in use. So from there to establishing fines, there's just a very small step. They say, okay, you can drive, but we will control what you're doing, and if you do any infringement of the laws, we will send fines to the bank automatically, and we will be deducting points from your driving license. And this is not science fiction. The steps are being taken to include assisted driving in all cars. So by 2025, we will be in a degree of artificial intelligence that will enable driving, autonomous driving, to be generalized. Level 5, that is. As the law always goes behind technology, well, some of the things that will be included in the software will vanish from the legal codes because they will become unnecessary. Not even the signals, traffic signals, will be necessary because they will be already included in the software of the map. So with smart contracts, it's the same thing. There are many people. Well, like the other day, I had a meeting with property registrators and banks about the criticism made against mortgages, foreclosures, which is socially unacceptable. So we are fed up, the banks were saying that we always get the blame, so we will make a smart mortgage that will self-execute in event of non-payment. So you can blame the algorithm, the computer, not the bank. So that's the direction things are taking. Everything will become automated. And I have several examples of, well, in which algorithms are fairly or unfairly blamed. In January, I went to Paris to visit my son who was studying, so all the family went, and Iberia puts us in totally different seats. I said, how can this be? We made a joint booking. I bought everything at the same time, but we are placed in 4 different places. But they say, no, this is the algorithm that attributes the seats randomly. This is the algorithm because you programmed it this way, because otherwise it was programmed. If you don't make a joint booking, the seats were adjacent. So you did this with a bad intention in order to offer passengers to put them all together for €6 each. This is what the Mexicans say. They're making fools of us. And they say, if you want to travel all together for €6, you can travel with your spouse. No, you have separated me in the first place. And so they blame the algorithm. Anyway, in the end, between those who blame the algorithm and not the programmers of the algorithm, and those who have the law that makes things a bit complicated, those people who approach the laws, they're innocently saying the laws will resolve our problems. Laws never resolve problems. They made it worse. So, because I've participated in many lawmakings of the digital law and the information society law. So in the Senate, we never introduce improvements. We introduce worsenings of a law, because every party wants to do something, and one article is always incompatible with the other. Because if the same author wrote the law, the entire law, that would be at least consistent. So when you write something together in open software, there's a consistency, a logic, and if someone is not logic, it's just booted. So in law, it's the opposite. Someone made a draft law from a ministry. They send it, goes through all the ministry, all the technicians say, okay, if you don't put this, I won't do that, and if etc., all these negotiations, and goes to the ministry, to the president, and then the Congress, and then the Senate. For it to be accepted, you have to accept amendments from other groups related to other laws. You have to barter and negotiate. Some of them contradictory with each other. So otherwise, they will just boycott the draft law. So then people say, I can't understand this law. You can't understand it because you don't know who introduced which amendment. We know the guys who did it, and they did it because it was part of the negotiations. And it's a totally incomprehensible amendment, which is deliberate. However, programs, they are logical and they can be understood. Here they make a deliberate confusion because there are things that's regulated by regulations, etc., can have different interpretations because it's not, languages are not exact science. So I wanted to show you a few cases of the last laws in which I participated since 1992, as I was saying, with the digital rights law. So I am like the grandfather who can talk about his amazing feats of the past. So if you have any doubts later on, maybe I could give you some hint about why things are the way they are.
La idea, por tanto, es...
Therefore, the idea is as follows. I'll share 3 examples for you to see that this is not complied with. So laws could be made using this flowchart. I studied arts, and in 1984 I could program BASIC with a Commodore 64. I knew the command was if go to, and then loop, and then I did it in my cassette storage unit. When I said that, then they look at me with high respect. That was useful to me because I wanted to know what were the insights of programming, and as I was following it, I said, well, this is formal logic. I come from the world of philosophy, and it was good to me because I could perfectly understand how a program worked. So it will be more difficult for me to explain how legal code is about. So when we are working in the e-administration, it would be very good for e-procedures to be displayed in this graphical manner. When I participated together with civil servants and IT people to make some procedures electronic, IT people do not understand. I said this procedure appears in 2 different places, why you should come back here. And then the civil servant said this is very important. It's important to them because they want that process to go through 2 different places, to be stamped on 2 different desks, and then the civil servants gain in importance the lengthier and longer the processes. And that's the reason why these processes are not simplified as much as it would be simplified if they were to be made by scratch by an IT person. When I go to electronic administration seminars and they claim that they want to digitalize everything, I say, look, if you have like shit and you digitalize it, you will be digitalizing shit. So therefore, that excuse of digitalizing everything and digital transformation is for them to undergo a pending revolution and to simplify administration. So the procedure should be simplified and public services, as a result of it, should also be made easier. So I'll show you 3 examples. So the most recent one, GDRP, it was approved in 2016. It was put into force in 25th of May. We were given 2 years to adapt to the European regulation. So in May 2016, it was already in force. So some people thought that 2 years was a long time. So we did not adapt to it in the last minute, and not because we were not ready. Citizens, people, Spanish Data Protection Agency, or not even the organic data protection law was ready to adapt to the European regulation. What does it mean when I say that it was in force and it was not in place up until 2018? Is it in force or not? It is in force because you cannot really adapt to something which is not in force. Actually, you cannot adapt a draft regulation. Countries were given 2 years, 2 years before penalties were imposed. Or, for instance, the same as the restrictions to drive through the city center. They set a day and they say, okay, so this should be complied with. As of this date, people who would not comply with it will be penalized. And as I say, between 2016 and 2018, there was time for regulation, for adaptation, and we said, okay, we should interpret the Spanish law and adapt it to the European regulation. And in those cases where there were no contradictions, the European Spanish law could be applied. However, the sanction system was that set out in the Spanish law. All right, I'm not going to tell you more about the actual regulation, but if I were to tell you which I dislike the most from the regulation, is a single word, which is this one. First of all, the old law from 1999 said, in the organic law, personal detailed data would be understood as follows: any information relating to physical people, either identified or identifiable. When we go to the regulation, definition is very similar. Personal details is all information, so any information about a physical person, identified or identifiable. And then it said the relevant party, because it is in brackets and in quotes, it may not sound or seem that important. That means that the actual physical person with personal details, and the personal details are those of those that are concerned about data. But I thought that we were the owners of the personal details. So this word, or the interested party, so the organic law talked sometimes about affected people and sometimes the interested people. And then I said that is the right terminology, because we are impacted or affected by the personal details. And now the regulation talks about the interested, the relevant party. So Spanish laws are very complicated, but European regulations are even more complicated, because 28 countries have to reach an agreement. Then there are different versions in different languages. And I highly recommend you take a look at the French and English version. If there are, in case of discrepancy, the English version may prevail. So the Spanish translator translated as the relevant person, whereas in English is the data subject. Same in French, why it has been translated into Spanish as the relevant party. So because I am the subject of the data. Why? So why are we only the interested party in the Spanish translation? Then if we consult Article 6 of the Spanish law, we can see that the basic rule of data processing, the first and foremost, was the consent given by the owner of the data. And if we were talking about the public interest, it was up to the companies to give that consent. And there were exceptions to the general rule. Whereas now, if we take a look at Article 6, that I didn't bring with me, but I have in my head, so it doesn't talk about consent anymore. It talks about legitimacy of the processing, and then making the public interest of the administration or legitimate interest of a company as exceptions. It says processing will be legitimate as long as one of the conditions below are complied with. And then it refers to it, I can't remember whether it says circumstances or conditions to be complied with. So same level of protection of legitimate interest and public interest. And now we understand why the owner is an interested party or relevant party. The public administration, companies, and private individuals, they are all interested party. So therefore, the data subject is no longer giving his consent. So this means that companies may be very interested in processing our data without our consent. So everything that they told us about the regulation being strict in terms of consent, it is not that strict. So the thing of having express consent, that has been established in the law since 1982, not even 1999 or 1992, but 1982. The data protection law, which is an administrative law, we have the civil law to protect honor and image and data protection. And in these cases, consent is always expressed. Well, different thing is that many people are not aware of that civil law for the protection of the honor and the image of the people. So all the regulations about the civil and administrative safeguarding of the honor and the image of the person, both civil and criminal. So if we have shifted from consent, where we express consent is being demanded for, but you open the back door to the legitimate interest of a company, and we don't know where that legitimate interest will finish, you may say there is a huge backdoor open, because if I mistrust the public interest of administration, I mistrust even more the legitimate interest of companies. And actually, we have a Twitter group where we talk about the legitimate interest. So I will show the photograph of Hill and his empire horse. So this very much expresses what the companies may do with your data just by claiming that it is the legitimate interest. If you put it in relation with article number 6, you see that all the interest parties are put at the same level. I am just one more interested party in my actual data. So the second topic, organic law of data protection. It was not up and ready for 25th of May, and it was approved in December. And in the beginning, it was not even necessary, because the European regulation is of direct implementation. But what happened there? It was said, well, some lawmakers are poets, and they said, well, this is a poor regulation, so it should not be open to any doubts, to any interpretation. Directives are often general, and because the regulation was not as it should be, say, okay, let us make a law to adapt our law to the European regulation. And then we said, okay, let us make it brief. However, the new law has more articles than the actual regulation. And actually, what happened was that the lawmakers, especially one of them, invented a whole new title, digital rights. Now it's LOPD and GDG, data protection and digital rights. Law should have only be limited to adapt our old law to the new regulation. So an organic law should have been made instead of this. But as I say, everyone was very much expecting to see what happened with article number 2, the right to oblivion in the social media, so many rights that had not been debated publicly. So lawmakers were not happy with that, and we said that that should have been debated in public. Then it goes through the cabinet. We were trying to lobby to have a round of presentations and meetings with experts. They said, no, well, we are very much lagging behind. So it was processed in fast track. And then when we got to the Senate, a friend of mine from Valladolid said, there is a third element here, which is a bit strange. So a new Article 58 was added, saying, use of technology means and personal data in electoral activities. First of all, gathering of personal details relating to political opinions of people that political parties will make within the framework of electoral activities will be safeguarded by public interest only when the necessary guarantees are delivered. So political parties may use personal data obtained through web pages and other sources of public access to carry out political activities during electoral period, sending electoral propaganda through electronic means and messaging systems, and hiring electoral propaganda in social media will not be considered commercial communication or activity. 3, 4, and 5 were the most widely debated, but these are not the most important ones, because electoral spam. One law I took part in was the SS2. There was a regulation already for commercial spam. So spam should be identified and then should have this unsubscribe message. I don't really mind the political party sending me an email asking me to vote them and to giving me the option to opt out. They will bother me once but not twice. But the problem is on 1 and 2. So having a database with personal data relative or linked to political opinions is barbaric. This is absolutely forbidden under the regulation. So they have included a final provision in the data protection law to authorize something that the regulation forbids, which is to say the processing of specially protected data such as sexual orientation and political opinion. There shouldn't ever be a database including political opinions. So this is not only for micro-targeting for spam, but using it in Cambridge Analytics to send to your Facebook wall fake news to foster hatred speech, because they are aware of your particular opinion and to find out and to be aware of what you hate the most. What they did in Cambridge Analytics was to do exactly that. Deliver information to you that would make you be really angry, so that you would end up hating other political parties. So these lawmakers, when they were at the cabinet with no public debate, not in the open, unanimously approved these amendments. So therefore, the law authorizes political parties? No. Political parties are authorizing themselves to do something that is forbidden to all companies and that is expressly prohibited in the European regulation. My friend produced a highly technical article about this element that had passed unnoticed to all of us. And when I read it, I said, well, this is Cambridge Analytics. And then when I read about the amendment that was put forward by the socialist group, that was later on approved by the other political parties, I said, well, because we just want to prevent the case such as Cambridge Analytica, where there was an illicit use of 70,000 users of Facebook, we include this amendment. I say, oh, what you want to do is to legalize Cambridge Analytica, so which is terrible. And then the speaker was saying, well, this is already being done. We just want to deliver guarantees. And they didn't even make these guarantees explicit. They just said the appropriate guarantees of safeguards. We took action, I tried to influence some politicians. I told them about the importance of it, and they said, well, it's a closed pact, it's a package of amendments, there is nothing we can do to reverse it. We produced articles about Cambridge Analytics. We made lots of noise, and we were about not to be voted in the cabinet. So some political parties withdrew Podemos, and they argued that they have withdrew because they haven't read through it, which is terrible. So we didn't read it. Now that you're telling me and that I can read it, I see that it is barbaric. It is not only that we will not vote on it, but that we will challenge it. So it was approved, and now it is in force. But no one put forward the challenge of not complying with the Constitution. And then two of us went to the Ombudsman. We put forward our arguments, 23 pages long, and then the Constitutional Court approved by unanimity the appeal. So it seems that it is not only us, for lunatic people, ombudsmen as well as the Constitutional Court have serious doubts about the constitutionality and legality of this provision. Sometimes it takes very long for constitutional courts to issue judgments. Let us see how long it takes. So hopefully they will issue judgments soon. So the last slide before we move on to questions and answers. It is the last directive I participated. This is a European copyright directive that has been out there for quite some time. I've been participating in this directive since 1996. I was a parliamentary advisor in 1996, and then later on I went to the Ministry of Culture. At that time, the digital agreements were signed. It was a diplomatic conference. I learned a lot, and I signed on behalf of Spain those digital agreements, and that became the 2001 directives in Europe. So 5 years later. Then, 5 years later, it was transposed to the Spanish legislation. So that was 10 years later. And then over that time, we had the directive that was in place in Spain was the one of 2001. So, well, the directive that has been enforced has been there for 18 years now. And at the time, there were no mobile telephones, no nothing. So, therefore, it was time to go back to it, to review it. And that was the purpose of that directive. Every Thursday, I publish an article in La Información magazine. So I don't know whether you know Les Luthiers. It's a humor group. So they ask, so I pay tribute to them, and then I just write about what has been trendy this week. And because this copyright directive was approved, I just wanted to write an article about the actual directive and my opinion of it. And other than the actual directive, for months now I've been hearing criticism against it. Very many fake things have been said about it. They are not grounded, or they are not true for that directive. But to understand that, we really need to find out or to know who was behind that. Oh, it's the Julia Reda. the MP of the main opposing party at the European Parliament. On the one hand, there were strange bedmates. On the one hand, we have Google, YouTube, other big players, and on the other hand, those lawyers defending those who do not believe in intellectual property. There was a very well-organized front against the directive, and Julia Reda did a much better work than the defenders of the directive. They started to filter misleading messages, twisted messages that did not match up the actual text of the directive. I try to be very rigorous in my legal analysis. If I tell you about 5 fake things that have been mentioned about the actual directive, at the end of the article I go and say, please find for me where the directive says that, because they say that this is what the directive says, but when I go and find it, I just cannot find it. Because they say, well, the directive wants prior censorship, filtering this, or prohibiting memes. So it is not only not true, but forbidding memes seems to be a big issue in this world. All this nonsense, ungrounded nonsense that have been said, I just go and said, please show me where it says that. Please point that at me and say, well, it doesn't say it, but this is interpretation. Well, it's your interpretation. That interpretation could be any other interpretation. So those apocalyptics say, well, the internet will be finished. And now the new internet has come to stay. So every single week, people are saying that internet will be destroyed. No, has not been destroyed. So we will see how to regulate and what are the mechanisms that will help regulate and defend the copyright without limiting freedom of speech. But some, at the end of the day, do not want to safeguard intellectual property rights. I'm against that. Those who are not in favor of IP rights, they are rightful not to be in favor of it, but they are not entitled to lie. And this is what I tried to write down in this article. To me, the gravest is filters. Yes, there are filters out there, because YouTube uses Content ID. Content ID works on the original movie. Then it does tracking and then sees a level of match. And then they can really see whether a person is not complying with the IP rights. And that is a filter, indeed, but it is not a prior filter. The problem here is prior or previous. It is not true that a filter should be previously applied to the content that is uploaded. It is not true. That will not happen because our Constitution forbids previous filtering. But if someone uploads a content that did not have the relevant rights, may be eliminated. But it is not true that the filter should be implemented before content is uploaded. Only that the word prior, previous, or general, this is not applicable to everything that is uploaded. It is only those that have an author to it, and where there are IP rights. Well, hashtags looks very nice, prior censorship, uploading filters. Those claims are not right, are not true. All right, so I would like to stop here so that we go into the debate. And there is something which I'm very much interested in, and it's also shared by lawmakers, lawyers, and IT people, especially those of us with a security concern. So lawyers study the cracks of the law and they do that to defend their clients or to improve the law whenever a loophole or crack is detected in the law. Same as everything, well, I've been fighting this battle for a long time, and I hate making hackers a synonym of cyber criminals. So I just always use the same analogy. Hacker is like same as a lawyer. Lawyer is good at legal certainty, whereas hackers are good at IT security. So both could potentially be criminals, but knowledge in itself is not a crime, but just the misuse that you make of it. I consider myself to be a law hacker because I take into account things that others cannot see or that pass unnoticed to others and that may make us compromise us, as well as our law system. And I always like to use this slide. It was moralized emblems of Hernando de Soto. This was published in Madrid in 1599. This one I especially like. Well, the only secure place is heaven. Olympus Mount was the only safe place. Do not ensure anything, or do not make anything secure. So there is no 100% security, neither IT or legal. However, altogether, lawyers and IT experts could try to raise the standard IT security standards as well as legal certainty. So these are my contact details. So this is the address of my blog. So my blog title name is Less Technology and More Security. So I've been speaking about law to not legal experts. I've been talking for many years. I'm working with many years with IT people, and I've always been interested in the legal aspects and side of it. So that's why I feel that it is so important that we work together.
Preguntas, ya sabéis que tenéis que colocaros en los micrófonos.
Questions, so please line up before the mics to make your question. This morning when we were talking about the keynote, I was talking for a call to arms against the new intellectual property law, not due to previous censorship, but because it was Scientology used intellectual property to veto the possibility of people to criticize their activities, and they exercised the right to veto a content againstment. And this could be previous censorship or not, but what we have gone through, in which we have 10 seconds of a Disney song and we cannot publish it. So my question is, what will happen even if we have these rumors about people write massively things that have a protected content, that in order to avoid being continuously in disputes, cease and desist kind of thing, they block everything, and as these other small guys who won't complain, so what do you think? My opinion is that you're entirely right. This is poor practice. It's not a poor directive. One thing is the rule, and another thing is the practice. And we needn't go to the copyright directive. At present, there is a true censorship on the part of the social media in subjects that are related to legal content. For instance, from Instagram with female nipples, but not the male nipples. So then I say, hey, why do you delete a content which is not illegal? Because the only limit to freedom of expression is the law. Well, I have terms and conditions of use, etc., and I set the norms as I please. No, this is not true. Companies, however multinational they may be, they have to submit to the laws and the Universal Declaration of Human Rights. When I studied law, the sources of law did not include the terms and conditions of usage of Facebook. We had international treaties, European framework laws, rules, regulations, etc. But we didn't have your conditions of use. These are contracts of adhesions like those we signed for the utilities. Where, in addition, where we can't negotiate the contract, when we say, yes, I accept, saying that we have read for the conditions of use, as we cannot negotiate, there has to be an authority that can read those conditions, and we say, with the ability to say, this is an abusive clause and it is null and void by law, which is what was done with the banks. So it cannot be that one day Mark will wake up and say, well, as from now in my networks, I don't want pictures of colored people. So what's wrong then with male nipples? So what is the criterion that Twitter would say, we want a polite conversation? A polite for whom? Where is it written that a conversation has to be polite? You give me tools so that I can build my social network and that I can silence the ones I don't want to hear, and I support those who I want them to follow. But you cannot tell me what I can or cannot see. This is damaging our freedom of expression, and with the excuse or without the excuse of copyright, because copyright is just another excuse, because in the end it is not a moral censorship. In YouTube they started taking income of YouTubers who said bad words. No, because advertisers said they didn't want to have their adverts associated to inadequate content. So what is inadequate? For whom? For the sponsor? So there is an increasing range of censorship, including what is politically correct, as well as self-censorship, which is the worst type of censorship. So freedom of expression is defended by exercising it in all areas. And we cannot consent people that will empty our freedom of expression simply because they say they are offended. Well, they should stop being offended because it is their problem. Because my freedom of expression cannot depend on the hypersensitivity of someone else, because otherwise I won't have freedom of expression. I am against the crimes of opinion in criminal law. I'm not even in favor of the crime of apology of terrorism. In the Basque country, in Spain, the problem is not that people support the terrorist organization, ETA. The problem is people who support that organization. So if someone puts a bomb or presses a trigger, it is a crime, of course. So we have to get used to defend the freedom of expression in social media. People say that if Facebook were a country, they would have 2 billion inhabitants. So then they come to believe that they are larger than countries and that they are above the law of each country. I totally agree with you. I'm a very extremist as you with the freedom of expression. It is there to defend the disagreeable context, not the complacent. Noam Chomsky said many times that if you do not believe in the freedom of expression of the person you detest, it's because you do not believe in the freedom of expression per se. Any question? Yes, I wanted to ask more or less in the same line about the Article 13. Is it 17? You see, you haven't read it.
No, yo no me quería lo de los memes ni nada de eso. Pues ha habido algo que has dicho que me ha llamado bastante
You
la
said
atención.
something that really caught my attention, which is that among lawyers, just like the hackers, we differentiate ourselves between good and bad lawyers. When I hear a bad lawyer, I get the image of Lionel Hoods, a lawyer who never wins a case. So do you differentiate among yourselves like this is just a money launderer or this is just a murderer defender? I haven't said good or bad. I said that there are lawyers that can infringe the law. There are also lawyers that specialize. From what I have seen, a successful lawyer in intellectual property. So the lawyers who more have defended the copyright are those who have clients such as the illegal websites. So I'm sorry, I'm in the National Commission of Intellectual Property. By my job, I have to defend intellectual property. They are my clients. They pay my wages. So maybe there's a terminology between of you of white liar, hardliner, whatever. Well, there are cool lawyers who are cool and those who are not cool. And then we have assholes just like everywhere. That's it, thank you. Any other questions? Thank you very much, Borja, for your presentation. Thank you. Congratulations, Rooted. As you are in data protection, and those who are in security know that there's not a lot of awareness about the situation of large companies. They have many failures, so when you start submitting budgets for cybersecurity, they think it's exorbitant. So I wanted to ask you about what you think. Well, we have a law that threatens fines. Just a few of them have been made. Data protection law infringements were maybe 15. So when will we get to a point where us computer people, we don't want everything based on compliance? We want companies to be safer for themselves and for their employees. What is your future vision about what will be done with law enforcement, fines and such? There hasn't been time to process all the reports of infringement. The process takes at least 6 months. So we're all waiting to see what happens with the first fines of the Data Protection Agency with the new European law. Maybe there's not an equivalence between the previous fines and the new ones. So let's see if we get more business with this, if companies take it more seriously. The first landmark was the date when the new directive entered force. And people were saying, we want you to renew your consent. And I say, well, I never gave you my consent, so it's not a question of renewing. So the best way to clear the inbox tray is to just delete these messages. So that was the first stage of such a silly thing as sending you an email. Now the processing of data, of personal data, is a different thing. Let us see now if the agency starts making inspections to see if companies have internally complied with all the obligations. As for the first part of your questions, why are people not aware of this? That is because we explain ourselves poorly. Us lawyers, lawmakers, we've done something that is very complicated. Like we've been working like high priests. Not even specialized come to agree on this. And this is a fundamental right that everybody should understand this. What can be done and what cannot be done with their data. I have proposed the agency and I've written several articles about this. This is the pedagogy of Sesame Street, because with Ippy and Blas, to explain concepts that even the idiot could understand, the reports that you have to publish about what can be done with data, they should be done with drawings, with illustrations, not to explain that to the agency, because I copied it from someone. This is not about examining yourself in front of the agency. If you don't understand it, how will your clients understand it? Write it in a language that you can understand, and then explain the client what will you do with his data. But the format, it is not necessary to copy the Twitter or the Google message. When I went to jurists and computer people to go to a company and tell them how important this is, they get sweaty and they get paralyzed, and they say, well, I try to make it easy for them. I allow the computer to speak, and then they just, their eyes roll over. People see that this is very complicated and very expensive, so I think we should make an effort to give each one what they need, not to sell an SME a huge plan for data protection that is valid for a company the size of IBM, because there are many companies are selling technology that SMEs do not need. This is what the agency did to help people to say, hey, this rule is devised for large multinationals, not for SMEs. Give me a small version so that everybody can understand, not only large multinationals. Any other questions? Well, apparently not. Yes, so congratulations for your presentation. It's been very interesting. I loved it. And congratulations to Rooted for the 10th anniversary. The question is focused on what you were saying about this adhesion to the new data protection law, the processing of data by political parties. What do I have to do to avoid them from making use of my data? Glad you make the question. Until the Constitutional Court emits a verdict, we can do 4 things. The first is to write according to a form that is on our website, PDLI, that is to exercise our rights of access, suppression, on opposition to the processing of data. The bad news is that you have to do this once for each political party. So you have to fill in the form and asking what data you have that belong to me, where to get them from. I want you to delete them and never process them again. And you have to keep a copy of this, because if they don't comply, you just report them to the agency. Second point, within the same law, there was an admission that we should send to the Bureau of the Census, asking them not to send our data to political parties. But this refers only to postal publicity. So then, some parties have created a Friday list. One was the Robinson list, and the Friday list is to register as a user that doesn't want his data being used. As this is a private initiative, you cannot oblige political parties to check it. The idea is that we should be many people in the Friday list, so that they cannot avoid checking with that list before sending advertisements. But political advertisements are minor problems. What concerns me is the use of our data for fake news or
todavía con la ley de protección de datos todavía no estaba en vigor el reglamento.
For example, the national pro-independent associations of Catalonia have been fined on the basis of the first referendum because they went door to door asking people whether they were in favor of independence or not. In this way, they created a database with people with name and surname, address, classifying them as independent, pro or anti-independence, and political parties that were created just to get data from the census, and a lot more serious when they got HB, a political party of the extreme left wing in the Basque Country, passing on their data to the terrorist group ETA. So until there isn't new legislation and some new government with a framework law cancels this section, well, until then we will not be at rest. So if we cannot realize that and we start making noise, all this would have gone unnoticed. We would not be talking about this. Now the parties know that we have that the agency has published a circular letter with guarantees that we are all waiting for this. So we hope they will think twice before engaging in these practices. Cambridge Analytica was discovered after a few years of activity. In the elections of 2018, they made a massive use of data obtained from social media, identifying the political ideas of the voters. So, who can delete any data in Spain? Do you think that when the election campaign is over, they will delete the data? In fact, once you have the database set up, the Constitutional Court will issue a decision. I understand they're being optimistic. They will vote for the elimination of those data, but they already have it. They have to be deleted because if you have data that is not supported by law, you will be caught red-handed. The thing is, the test, the evidence, the burden of the evidence. So in Cambridge Analytica, well, it just was unearthed. Someone may take a revenge because he's being sacked or whatever. What I hope is that everybody will be very careful because maybe an office of political parties sent a chain of WhatsApps and it came out in the press next day. So things have to be done, but very well, with care. So anyway, having a norm and a criminal code that forbids murders or makes murders a crime doesn't mean that nobody will commit a murder. What we want is for this to disappear, and that anyone who engages in these illegal practices will be heavily fined. Thank you. I'm sorry, someone was whispering in my ear something. So, Borja, thank you very much. So, before you leave, well, a big hand for Borja.